Well, it is a pleasure on this Tuesday morning to welcome to our studios Jill Dougans, who's here from FH&P, and we're talking about marijuana as it pertains to the average Canadian. And Jill, good morning to you. Fascinating subject, and kudos and good on you for picking this one for a Tuesday morning law conversation. Where did that whole process start for you?
Thank you, Phil. It's good to be here. So the reason I wanted to come and talk about this today is that in my personal injury practice, I am starting to see people who have been injured in motor vehicle accidents, who have chronic pain. They might be suffering from PTSD or anxiety as a result of the accident, and they are talking to their doctors about access to medical marijuana to treat those conditions.
Now, in the past, they would have been prescribed, an opioid. They would have been, who knows the drugs that are in that category. But any number of drugs would have been prescribed. Now, are they saying by choice, I would rather not use the chemical drugs, I would rather use marijuana?
Well, a lot of those drugs come with a lot of unwelcome side effects. Mm-hmm. And especially in the case of opioid and narcotic medications, they lose effectiveness over time, and they're addictive. And many people are very, very concerned about using those sorts of substances on a long-term basis. And many doctors don't want to prescribe them on a long-term basis either. So medical marijuana may present them with a relatively benign way to address chronic pain, anxiety, PTSD, with a substance that, as far as we can tell, doesn't have terrible side effects.
But at the same time, has medical marijuana shown to be effective in dealing with the symptoms, if you will, that normally we would treat with an opioid or a chemical prescription?
Yes, but most of the evidence is anecdotal. There haven't been a lot of major studies and reliable studies over a long period of time, and that's part of the problem with where medical marijuana fits into our health system right now. It's not a drug. I mean, it is a drug. It's not a prescription medication.
Right. So
doctors don't prescribe it. They give patients an authorization to purchase it.
Yes, and depending on who you are, may depend on how significant that prescription is. Members of the Canadian military, for instance, will be given a medical prescription that will do and give them 55 grams a day. I think that's the number. I don't know why that comes from the back of my brain, or maybe it's a week.
That sounds like a lot. Because the authorization form that's available to most people, and I don't know about the military, but it authorizes between 1 and 5 grams a day of medical marijuana.
Okay, so I think the 55 number is a month then, because I do know that the federal defense minister was under some heat and some fire because there were any number of members of the Canadian military suffering from PTSD that were getting off of chemical dependency, had chosen marijuana as their source of pain relief and all the other troubles that went with their PTSD. And then suddenly the federal government was standing up and saying, well, we're prepared to accept the fact that the federal government has a responsibility to accept the medical costs of our military, but we're going to limit how much marijuana you can smoke. And so an arbitrary number. And I know it was 55 grams, whether that's a week or a month. As you're indicating, that's a lot in one day. So my figures may be, my information may be slightly screwed in my brain here, but I do know that the 55 number is correct, okay, whether it's weekly or monthly. And the federal government had put a limit on how much they were prepared to pay for members of the Canadian military.
But I think you've hit on what I think is the number one problem is the cost of medical marijuana. It's very, very expensive. Mm-hmm. So a gram of marijuana from a licensed producer will be anywhere between $5 and $15 per gram. So if you have a prescription for 3 or 5 a day, that's how much money you'll be spending a day on this treatment.
Right.
So, and if you look, you can go on most of the websites of the licensed producers, and they'll show you their prices, and they'll tell you about the product and what it contains. So most times it's going to be $7 to $9 a gram.
Right. So, extending this further then, are you surprised to hear that Loblaws, with their multiples of thousands of employees across the country, coast to coast, which here in Kelowna would include Real Canadian Superstore, which is part of the Loblaw chain, and then, of course, Shoppers Drug Mart that are now owned by Loblaw, that they've both indicated that they will cover under medical insurance in their employee benefit plan medical marijuana. And so suddenly these thousands of employees right across the country can now start submitting bills and expense forms, prescription forms, whatever you want to call it, for medical marijuana.
I think that's a great development. I think that's a fantastic development, and kudos to them for stepping out and being a leader in that area.
Yeah. I guess the statements that were being made was, if it's good enough for Loblaw and it's good enough for shoppers, it is an indication of where acceptance is going to go in a hurry in this country. And now the government of Canada needs to catch up, because I think that personally, Canadians have indicated to the tune of about 87%, I believe, is the survey that would say that Canadians want the government to do this, to legalize it and make recreational marijuana acceptable. And the government, in the minds of a lot of people, seems to be dragging its heels and going as slowly as possible. And the other side of it is that they've downloaded a huge amount of responsibility for this onto the provinces. The provinces have to determine what the price is going to be. The provinces have to determine how and where it's going to be sold. The provinces have to determine whether or not they want a bigger or a higher age limit than 18. The federal government is going to set it at 18. But all the provinces now have to determine whether 18 is good enough, or do we want it at 19, or do we want it at 21? And so a lot of people are saying, yeah, well, it might be nice for the federal government to say July the 1st, Cannabis Day. But for some people, they think it's going to be a lot further down that road before it becomes legal in all provinces across the country, which is a conundrum for the government of Canada.
Well, you know what? Everyone has their work cut out for them. Mm-hmm. Everybody. That's, municipal governments who are going to have the actual dispensaries in their communities, provincial governments, the federal government. Then we've got to deal with international issues because marijuana is not legal in every state in the United States, so we're going to have cross-border issues. So there's no end of work for everybody here. But eventually the price is going to come down because there will be more and more licensed producers. So there's 43, when I checked Health Canada's website, 43 licensed producers right now, 9 in BC. Across Canada, 6 are new licenses as of 2017. Interestingly, there are 25 in Ontario and only 1 in Quebec. Mm-hmm. What's up with that?
Right.
But we are eventually going to see that as we have more and more supply, we'll see the price come down. And right now, price is a big barrier.
Right.
And so where I see it in personal injury claims is that people who have chronic pain from motor vehicle injuries or PTSD, anxiety, those are the 3 conditions that in my practice I see the marijuana authorized for. The claim for a lifetime use can be in the hundreds of thousands of dollars.
We're going to take a break here. O'Hara said, let's take a break here so that we can then create a window and get into the subject, the cost of future care. Because that is the larger unknown, and when you start talking in terms of $100,000 over a lifetime or more, that's enough to get a whole lot of people sit up and take notice. We'll be back with Jill Dougans from FH&P. It's our Tuesday morning law talk. Back in a moment. Jill Dougans is in our studios. FH&P Lawyers is her home, but it's a pleasure to have her here because we're talking about medical marijuana and, in particular, the side of the story, which is the cost of future care, as people are willing to turn their backs on opioids and the chemical treatment of pain, PTSD, and all the rest of it. They're willing to turn their back on the chemicals that the medical system wants to prescribe. And instead are willing to want to look towards medical marijuana for the help that it can deliver. Jill, as we were in the break, you said, Phil, before I leave your studio, there's 2 things I want to go to. And one is the difference between CBD and THC. which are three letters in two different groups. One is the hallucinogenic, which is THC, that everyone has these images of the stoner. And so let's start there. Is that THC, yes, delivers a stone. CBD does not, but it is the marijuana with the medicinal benefits.
Right. So there are two plants. There's the hemp plant and there's the marijuana plant.
Right.
Marijuana plants have a lot of THC and not that much CBD in them. Hemp plants are the opposite. They have lots of CBD, not so much THC. And it's important whenever we say marijuana or medical marijuana to at least think in terms of those two different compounds. There's actually hundreds of compounds in both of those plants. The THC, that's the compound that gets you high. It's a hallucinogenic. It may have some medicinal properties, but it's much more likely that the medicinal properties we're starting to see and the disorders that are treated are being addressed by the CBD in the plant. CBD will not make you high.
But it does deliver medicinal benefits relative to pain, relative to in some cases, in the minds of some people, seizures, muscle problems. There's a long list of things that CBD can work with. Yes.
So, I mean, for me, I think that's where the exciting work is going to be done, is as we explore the CBD, which hopefully people won't have to smoke marijuana to get the benefits of it, because that just seems crazy. It's so unhealthy to smoke anything.
And you know, in your research, have you come to any understanding why the federal government insists that as medical marijuana will be delivered across the country through Purolator or through any one of the Purolator companies, delivered in a plain brown wrapper, that as your medical marijuana is delivered to your home, that you only receive it in one form, which is the dried leaf, which must be smoked to achieve the benefits. Have you figured out why?
I personally haven't figured out why, except that they were jumping on a bandwagon before they had other products.
Right.
I don't know
other
why.
products being the potential to have it infused into edibles,
edible oils or capsules, or we do have actually a synthetic marijuana product that is a licensed drug that can be prescribed, and that's Sativix. It's a nasal spray.
Right.
And we have Nabalone, which is another synthetic marijuana product. So there are a couple of forays into a non-smoked product.
But the reality of the market is that as
people are smoking it. If you have medical marijuana, you're probably smoking.
You're probably at this time, or vaporizing it at the very least, which sort of lessens the impact on your lungs. But just as easily, wouldn't it be nice if you could have some sort of a butter and spread it on your toast in the morning? Or wouldn't it be nice if you could add a few drops to your smoothie? Or there are so many other ways that you could achieve the medical benefit.
Without ruining your lungs.
Exactly.
Yes.
Exactly.
That's what I think.
What's the reaction of the people? And are you now seeing people in your practice who are coming to you and indicating that it is their wish to have you assist them in developing their case or developing some sort of pro forma that indicates that this individual has been challenged with these medical infirmities or this accident and they deserve the right to obtain or access medical marijuana. Is that the play that you're involved in at all?
Well, no. The people who've been injured in an automobile accident, whether or not they use medical marijuana, that's a medical decision. So they will talk to their doctor. No doctor in Canada is required to authorize the use of medical marijuana if they don't want to or they don't feel they know enough about it.
They can refer you.
Exactly. They'll refer you. And there are enough physicians that my clients, you would be able to find someone who could evaluate you and if they thought it was the right thing to do for your condition, they could sign an authorization for you to get medical marijuana. So I'm not involved at lobbying for it, or you don't need a lawyer in order to get an authorization for medical marijuana. But if you have a personal injury claim, one of your heads of damage is going to be the cost of future care. Future means anything after your trial or after your settlement. So if you're going to have out-of-pocket expenses in the future to treat your injuries, and that is anything from medications to physiotherapy or a kinesiologist and a gym pass, or it's assistance around the yard. It could be
I need to jump in
a wheelchair.
Here, though. I need to jump in here is that you've just listed all these things that sort of become an element of the continuing care context. But at this time, if you were to try to write medical marijuana in there to the tune of anywhere from $7 to $9, as you've indicated, per gram, 3 grams a day, you're telling me that this could cost almost $9,500 a year. If you wrote that into
yes.
a claim, would you have trouble getting that past a judge right now?
Yeah, I think you'd have some trouble for a number of reasons. So I've taken a look at some of the recent cases involving awards that include medical marijuana, and I see that the judges are very conservative about it because it's a new treatment, because the market is so uncertain. We think the cost will come down, but we don't know when. I see the judges being very conservative, but I do see awards being made. I saw one recent case where an award was made for technically lifetime marijuana use, but it was very, very, very small. It was like 4 grams a month. So the cost of it was really not prohibitive in terms of the overall claim. It wasn't hundreds of thousands of dollars. But if you're smoking 4 grams a day,
right,
well, then suddenly that's a very, very expensive claim.
Right. And so if you're not getting satisfaction, do you have the ability to go back to the judge and say, with the greatest of respect, Your Honor, please listen to the case my lawyer can now present, and basically this is an attempt to increase the settlement, and this is an attempt to justify the increased claim that we're making?
So once you've settled your case, no, you don't have any recourse to the courts once you've settled. And once you've been to trial, the only recourse you have is an appeal if you have grounds for an appeal. So you've got to make your best case before you settle or at trial for this award for the future. And I mean, that's an argument we frequently make is to the judge.
So you just opened up a whole avenue here that I've got to ask you this.
Sure.
So 3 years ago, I was involved in a horrendous vehicle accident. I'm still on painkillers and whatever. I'm still having blackouts. I have all these things that are happening to me. And my doctor willingly and happily writes me prescriptions for any number of the opioids that are out there. And it costs XYZ dollars per year. So there's no trouble whatsoever going to a judge and saying, and here are the costs that are going to be associated with my client for the rest of their life to the age of 75 or whatever. And the judge signs off on the bottom and the deal's done. You're telling me now that 3 years later, as I now have an awareness and I realize what I'm doing to myself chemically and the long-term impact on those chemicals, and I've learned since that medical marijuana will be far more advantageous to my case. Are you saying that there's no ability to go back and have that reopened and say, Your Honor, my client wants off the opioids, my client wants to shift his medication to?
No, you cannot do that.
That's wrong.
If you go to trial, that is your one opportunity based on the best evidence available, including the best expert advice available. The court will make an award for you for the rest of your life. And that's it. You cannot go back because circumstances change.
Improved medical knowledge, a greater... Seriously?
No.
Why would that be?
No. Well, because we need some certainty. Otherwise, people would be coming back all of the time to redo awards as circumstances changed. But here's another observation. If you get so much money for your future care, and then it turns out that you recover after trial and you don't actually need those future care items, you don't have to give that money back either.
Okay.
I don't know if that's providing you with any comfort.
No,
but
and I hear what you just said to me. That's fine. So
your trial, that's it.
If you're now out of your wheelchair, rise Lazarus and throw away your crutches, and you now can make your life through life with a walker and a cane instead of being stuck in a motorized wheelchair. And yet the costs are still associated with that motorized wheelchair and the kinds of care that are associated with that, et cetera, et cetera. So I recognize that number is established. But at the same time, I have a hard time getting my head around this. I'm sorry that the law is going to insist that I am going to stay committed to physically harming chemical drugs that over a long period of time will have a deleterious or a very negative effect on my organs and on my health. And the law says, well, tough, buddy, that's where we're going to keep you.
Well, yes and no. So once you go to trial and get an award, how you spend your award is up to you. Right. So you can decide if you get so much money for cost of future care, for opioid medications, of course, you can decide, well, I don't want to take them anymore. So
thank you.
But so all they're doing at trial is coming up with a number. At the end of the day, it'll be one number.
Boy, did you just lessen my stress levels. So I can take the opioid chemical amounts and redirect them to acquiring medical marijuana.
Absolutely.
Okay, I thought that I was destined and doomed forever to be dealing with these prescriptions as renewed by a medical fraternity who keep examining me and saying we're going to keep you on the chemicals.
No, so the cost of future care award is an estimate.
Lump sum.
Yeah, it's just an estimate of what your future expenses are going to be. The courts say it has to be supported by medical evidence. It has to be what's reasonably necessary for your physical and mental health. This is the test that the courts apply. So, yes, the court will do its best to figure out what that number has to be. It'll be made up of a number of components, like your medications,
right,
like your physio, like modifications to your home, etc., whatever the...
To put in the wheelchair ramp and to expand the hallways and to lower the light switches and.
Yes, okay. And the court has to be convinced that you will actually take advantage of those things. But in fact, the day after the trial, you get your award money, how you spend it, it's totally up to you.
If you choose not to put the wheelchair ramp in, that's your choice.
That is your choice.
All right. Jill Dougans from FH&P is here with us on this Tuesday morning. It's our usual Tuesday morning law talk. Find the conversation absolutely fascinating. She's also sent me a couple of scenarios, and there's just one that I want to go to right after this break. It's the story of a plaintiff injured in a motor vehicle accident, soft tissue injuries, $150,000 as a lifetime award. But there are some other bits and pieces of this story that I think you might be interested in. We'll be back in a moment.